Morning, everyone. I am here today to record my presentation, which is known as Avoiding Malpractice Claims in Litigation Matters. My name is Ed Clinton Jr. I'm with the Clinton Law Firm in Chicago, Illinois. I have been practicing since 1991. This is a brief overview of my background. The goals of the presentation are I want to assist litigators in preventing malpractice claims against them. My goal is to make sure that you avoid claims in your practice. I look at this from the perspective of a legal malpractice lawyer, plaintiff's legal malpractice lawyer. And then you should understand that legal malpractice cases are only going to be pursued if there's a path of proving that the lawyer's error caused the client to incur significant economic damages. However, state bar regulators often prosecute cases of negligence that lawyers would not take, plaintiff's lawyers would not take, because they regard the acts as pretty shocking or outrageous, or the work as being below the standard of competence. So there are many areas where the state regulators will take up an old-fashioned negligence case and turn it into a discipline case and bring it against the lawyer. I'm an Illinois lawyer. The course is focused on Illinois law, but I'm going to draw examples from other jurisdictions. The common law of negligence is the basis for malpractice liability. That is, the law is basically the same in every state. Here's our main topics: legal framework of the malpractice claim. We'll discuss a little bit the role of the rules of ethics, and then the three big errors that get litigators into trouble: statute of limitations, failure to prosecute litigation, which could be otherwise talked about as the duty of competence or the duty of diligence, and then error number 3, conflicts of interest. Conflicts, just understand that conflicts can be subtle, particularly where an organization is a client. And then remember that if it really is a judgment call, the lawyer chose between two equally plausible alternatives based on his judgment and experience, that it's not malpractice. So the plaintiff, looking at your case, the case you handled and obviously lost, because you won't be sued if you won. Malpractice lawyers are well aware that half the cases are going to be tried and lost, and that's not negligence. Malpractice lawyers will avoid any case where the damages are hard to quantify, understand, or prove, and then almost every malpractice plaintiff has a cutoff. In today's world, given the cost of pursuing litigation, I would imagine that most malpractice lawyers will not take a case where the proven economic damages are under $100,000. Again, the caveat is the state bar regulators may take a case where the economic damages were zero, but the client suffered real demonstrable harm. Areas where state regulators will take cases against lawyers are immigration, bungling up a family law matter. There may not be actual damages, but there may be a lot of real suffering the client had. So those cases are often pursued by the regulators. This is the basic framework of a legal malpractice claim. The plaintiff has to show that the defendant owed the client a duty of care arising from the attorney-client relationship. The defendant breached the duty, and the defendant's breach was the proximate cause of the plaintiff's injury. In other words, the plaintiff, the lawyer who caused the plaintiff's injury, and that can often be difficult to prove. Your best defense to a malpractice case is selecting clients. If you select clients who are not good human beings, you will suffer more claims against you. here's some clues to help you determine whether the client is a person you should represent in litigation. Did the client have a number of prior lawyers? How many prior lawyers in this particular matter? That's usually not an appropriate. If the client's always changing the lawyer, then you have to ask yourself why they're doing that. And there may be a reason. So if someone had one lawyer and they came to a dispute with that lawyer, that is a reasonable one or two lawyers. But more than that, it becomes very problematic. And the more former lawyers the client had, the higher the risk you are, you'll get sued. Obviously, clients are concerned about cost, but unusual concern about cost. Something odd about the way the client approaches cost. Like they say they'll do some of the work themselves and have you sign it. Something like that. That would be a clue that that's bad news. Obviously, you want to avoid clients who lack integrity or are dishonest. And then the classic, the final one is anyone who's vindictive and motivated by revenge. This can come up in the family law area or in the estate area. If they're just trying to hurt someone else in their life, they're a trouble spot for you because they may eventually turn their anger towards you when things inevitably go poorly for them. If you are coming into a case where there was a prior lawyer, you should obtain permission to talk to the prior lawyer about the case, to get the background of the case, why the person withdrew. And if the client declines you permission, do not accept the case. The engagement letter is your contract with the client, setting up the terms of the representation, and it is your self-defense to all sorts of claims. I would recommend for most litigators to exclude handling an appeal in your letter. If you do trial work, say you don't sign on, make it clear that you're not signing on to do the appeal. Make sure that that's a separate agreement, that you've thought that through. And then also, always put in the letter that the provisions of this agreement shall apply only to the matter outlined above. In other words, you do an engagement letter for each matter. There are 3 cases, do 3 letters. It will really make it's more orderly. It creates a rigid framework for the client to proceed, and it also protects you from the claim that comes in that out of left field, that you didn't see coming because you didn't know about it. If there is no engagement letter, the court will decide whether there's an attorney-client relationship between you and the plaintiff based on the plaintiff's reasonable understanding of the conversations and communications. And where you can get into trouble is if you don't lay out who you represent. So you get involved with a small business, there are 2 or 3 owners, a dispute arises between one of them and the group. He says not only the lawyer for the company was his lawyer, as far as he understood, and in many cases the court or the disciplinary regulator will say, well, he has a reason to believe that you were his lawyer because you never told him you weren't, and you acted like you were his lawyer. So if you represent the business and there's some type of litigation involving that business, make sure you've thought through who you represent and you've put that in writing, so you don't end up with a claim coming in from an owner who was treated poorly by his colleagues that you didn't protect him. Then the other one is to remember also to think about any types of, if you work for an organization, think about ambiguous situations. The company asks you to investigate some type of allegation of wrongdoing. You go in, you say, I want to interview this employee. Employee comes in. Make sure you explain to that employee that you do not represent him. And then tell the employee that you're not going to keep his words confidential. the investigation will inevitably can involve serious matters. It could be a serious issue of wrongdoing, but you should explain to the client you're not his lawyer, and that if he needs his own lawyer, he should get one. Just make sure you don't let that employee who's under investigation think that you represented him. That will lead you to trouble and suffering. Prominent example of this failure to really understand who you're representing was the unfortunate case of the Penn State University, which went through some tough scandals over 10 years ago. Eventually the president of the university, Graham Spanier, was subpoenaed to appear in front of a grand jury to discuss how the university had handled some sexual misconduct lawsuits, claims. He was represented in that hearing by the general counsel of the university, who was a distinguished member of the bar, a former justice of the Pennsylvania Supreme Court named Cynthia Baldwin. Later, Baldwin testified to the grand jury herself and testified against the president, Graham Spanier. In other words, there was confusion. Did Baldwin represent Mr. Spanier, or did she represent Penn State, or did she represent both? The end result is that because she didn't make it clear, Cynthia Baldwin, again a distinguished jurist, was reprimanded by the Pennsylvania Supreme Court for essentially not thinking through who she was really representing. And once she was called in front of the grand jury, did she inadvertently or share client confidences with her other client, the president of the university? And there was a conflict between the two, because the argument in the whole scandal was the president had mishandled the allegations of sexual abuse by a football coach. Well, testifying against your client was a serious matter. Unfortunately for Ms. Baldwin, I don't think she thought through who her client was before she got involved in the matter. And she should have told the president of the university to get his own lawyer, and that she wasn't going to represent him in front of the grand jury. And once she got involved with him, she really had to quit as the general counsel of the university. She couldn't maintain duties to each client, and it ended up with a public reprimand and an otherwise sterling, distinguished legal career. And it's unfortunate that this happened, but you got to think this through. Hey, wait a minute, there's a conflict here. Who do I represent? Let's talk about self-defense basics. As I said before, use multiple. If there are multiple lawsuits involving one client, use a separate letter for each one. Put a clause in the letter saying any modification of this agreement should be in writing, signed by both parties. And then for a plaintiff's case, if you're going to do plaintiff's work, I strongly recommend putting a clause in the letter that explains how costs are going to be dealt with. In other words, is the lawyer willing to advance the costs? Are the costs going to be charged to the client as the matter goes along? How is the expert going to be retained and paid for? And by putting this in the letter, you will hopefully get the client to ask questions early on, like what are the costs I have of pursuing this claim? Well, here are your costs, client. You're going to need an economic witness, an accountant to say what your damages were, and you're going to need a standard of care witness. We're going to have to bring in a witness to say, this was the standard of care, and it was not met in this case, and that's going to cost, between the two of them, that's going to cost you X number of dollars, and that's going to be deducted from the amount you recover. This is obvious stuff, but always confirm important conversations with the client in writing. This protects you from the claim later that you did not discuss something with the client. And the classic matter is a settlement offer. Tell the client about that offer in writing. Explain it to the client. And then document the client's decision. The client decided to reject the offer. Okay, fair enough. This is a footnote to that discussion. When you have important conversations with the client, document those conversations. You could create a memo to the file, or you can write the client an email or a letter explaining that this is what you instructed us to do, and given the merits of the case, it's our professional opinion that you should reconsider and accept the offer. You should make a counteroffer. Tell the client what you think, that's what you're paid to do. And as a young lawyer, sometimes I was a little too reluctant to speak my mind, and I think I would have been more effective if I had spoken up and said, you should take the money, or you should drop this lawsuit, or if you file this case, there's going to be a counterclaim against you. Speak up. Tell the client what you think. You're being paid to give candid advice. Tell the client these are the risks of proceeding as you have told us to proceed. This is a case from New York. It's not an incredibly important case, the Scarola case, but the lawyers were hired by a client in a commercial litigation matter. The client then, when they sued for fees, the client claimed that the lawyers should have pursued a different strategy in the underlying case. And the lawyer said, no, you instructed us to be aggressive and to fight tooth, claw, and nail. So you imposed your strategic imperatives on us, which we then followed. And now you can't change your mind after things turned out poorly for you and sue us for malpractice. And the court agreed. The case was dismissed. It's an important case because these are lawyers who documented their file and said, this is what you want, client. We understand. This is the strategy you have chosen, an expensive, difficult strategy, as opposed to a more collaborative strategy or recommending mediation or settlement. Can't say this enough. Share all bad news with the client. You will see in every matter there's something bad's going to happen. Tell the client what happened and tell them why it's bad. And then clients won't ever complain that you communicated with them too much. A little example from my life. I worked in two large firms. In one of the firms, there was a huge piece of litigation involving several parties. There was a team meeting with the CEO of both of the main companies on our side of the case. Plus, several firms were involved. There was more than just the large firm I was part of. One of the young lawyers from another firm said, this case, we should try to explore settlement in the case. My boss and a couple other people spoke up and said, no, you're speaking out of turn, you're too young, you're too junior. The client said, stop, I want to hear what this person has to say, and he listened carefully to the advice that was given. The client said, I want you to tell me what you think. So if you feel strongly about something, tell the client. Tell them what you think. Don't hold it back. Don't hide it. And this young person, it wasn't me, acted courageously under the circumstances and gave his opinion. And it made an impression on me that he was willing to take the inevitable abuse that was heaped on him from breaking the team's uniform message. He was willing to go off script. He was willing to give his candid advice to the client, and the client appreciated it. When you inherit a file, look at that file right away, because there may be something that went poorly in there, like, oh, we forgot to disclose an expert, oh, we missed a key deadline. jump on top of these things as quickly as you can. Review that file quickly, and don't sit on errors by a prior counsel. In other words, tell the client about it immediately, or even a potential error. Say, here, we're moving to extend we're going to move to reopen expert discovery so that we can disclose a standard of care witness. But don't let when you inherit a case, don't let it sit in your office for a year, then realize that prior counsel made a mistake, missed the statute of limitations on a claim. Because now you are going to be roped into that. Inevitably, that malpractice claim will include you. So we're going to talk about typical kinds of claims that lawyers can unfortunately encounter. The most common claim you're going to have is that you missed the statute of limitations on a lawsuit. You don't want to have any of these be filed, but in any active litigation practice, there's always a risk that a deadline gets missed or that something is misunderstood or miscalendared. So, the way to avoid this is to be up to date on your calendars. Think through how the statute of limitations is going to play out in a case. Like when was the accident? Oh, it was on this day. Well, we have X amount of time to sue, and then think through, for your own protection, setting up internal procedures, calendars, have meetings in the office with your colleagues to discuss upcoming deadlines. And then there's a good reason to have a system in place to decline cases where the client comes in and says, by the way, in 6 days the statute of limitations is going to run. If you take that case, you are asking for trouble, because you might miss a responsible party, you might miss a claim, and you might therefore have inadvertently committed malpractice because you didn't have enough time to learn about the matter. So you say, if you don't come into us with at least 3 months to go, we won't consider the case. And how you can get burned, you are not going to be burned by something you see. It's something that you didn't know was out there. The example is the product liability case, where there's a couple of manufacturers that are hard to find, and it's subtle who committed where the defect occurred. There was some type of part, and it has 6 or 8 components, and you miss one of those manufacturers in Taiwan, you don't sue them within the time, you probably can't sue them. You've lost a claim. So, and then for defense lawyers, always think about the statute of limitations. If your client is sued and you represent a professional, was there another professional who rendered services who should be added in a contribution claim? Should we also say, hey, this was also the fault of not just the fault of the surgeon, but it was also the fault of the pathologist or the radiologist or the internal medicine doctor? In Illinois, you have 2 years to assert that claim after you're sued. So you want to think through: should we add a contribution claim in? Should we, or in the building problem, should we sue the architect? These are areas where you can commit malpractice because you didn't think about this quickly enough. Another adventure in my own 35 years as a lawyer, I took over a case pending in federal court. The client's prior lawyer had caused a mess, which led to a number of sanctions motions being filed. I was hired by the client. I went out to the federal court in question. I defended the lawyer's conduct in front of the magistrate judge. The magistrate decided not to sanction him, and not to sanction the client. But unfortunately for us, the other side appealed, and I was not confident that we would win the appeal. So I told the client, look, action by prior counsel may have been a malpractice, may have subjected you to substantial fees and sanctions. And then I also, in an act to try to move things forward, I also settled a dispute. The client then turned around and sued that lawyer, the lawyer who caused the mess, allegedly caused the mess. They sued him for malpractice, and he then filed a contribution claim against me. Well, he said I contributed to it. This was a painful experience, but the court eventually decided that his claim for contribution did not really state a claim, because I had only come in and settled and cleaned up the mess rather than made it worse. But again, there is some chance that by getting involved in that and by candidly telling the client that you could subject yourself to, you could get added into the case too. So this is just part of life. And when the contribution claim is filed, the court won't. It takes a little while to sort that out. The claim against me was dismissed, but it probably was pending for a year. I put this in every presentation, having represented lawyers. When there's something bad happens, if you make a mistake, tell the truth. Tell the boss of the firm, tell the client. This will protect you from discipline. If you conceal a bad act, you are putting your professional license at risk. You are also, it's a terrible act to both the client and to your colleagues at the firm, because the client now doesn't know the truth. So tell the truth. When something bad happens, if you drop the ball, own up to your errors and be truthful with clients and with the firm. Talk a little bit about the duty to prosecute litigation. This is a source of claims against lawyers. Many lawyers have been. You can easily get sued for this. We all know we have a duty to provide competent legal work, but if there's a case comes up in an area that you don't understand, ERISA, taxes, and securities are the three areas I think are most likely to generate an off. They're niche areas that can generate a claim, or you can make a mistake. You've got to find co-counsel. You've got to do something about that. Tell the client, I don't know about securities law. I don't know how to deal with this. I don't know how to deal with the issue of how to appeal a foreign trade dispute. I'm not competent to do this. Tell people so that the matter can be addressed. Sometimes that means you will lose the matter, but it's much better than making an error that would harm the client and or yourself. Another part of the duty to prosecute litigation is the importance of discovery deadlines. If you miss a deadline, you're opening yourself up to a case. So when you think about it, think long and hard about all the deadlines in the case. Don't miss that expert deadline. Don't miss the answering interrogatories with the damages information. Don't miss the pleading an affirmative defense. Calendar your deadlines. Meet with your colleagues. And then for the larger important cases, make sure you planned out how you're going to do the work on the case. I've discussed this before. Does the plaintiff need an expert? How many experts do you need? Who's going to pay for them? If the client won't pay for the expert or doesn't want one, don't take the case. Conflicts of interest. This comes up in two ways. One is you represent two parties in litigation. The other is that some former client you had in a past life is impacted by the current case, and you have caused harm. So think through, for current conflicts. Think about whether the representation of one client could harm another client. Is there harm that could be caused? You represent the company. You also represent the president of the company. In the case involving Penn State, the general counsel of the university represented the president of the university personally. She went with him to court before a grand jury, and she represented the university. was that something she could really do? Is that something, her duties to one client are going to inevitably bring her into conflict with the duties to the other client. So think about those things. Conflicts are a great way. Plaintiffs' lawyers love conflicts because everybody understands them. Any juror will understand the conflicting loyalties. They totally get it, and it doesn't take a lot of fancy legal work to explain a conflict to most people. Most people completely understand that the loyalties were divided and something bad happened, and they'll blame the lawyer for that. Former clients, the Rule 1.7b, a lawyer shall not knowingly represent a person in the same or substantially related matter in which a firm with which the lawyer formerly was associated or had previously represented a client, whose material interests are materially adverse and about whom you've acquired confidential information that's material, unless you get informed consent. The classic examples of this: you represent two people, two business partners for years, they get in all kinds of things happen to them, and then eventually one sues the other. Well, you're out of that case because you know confidential information about both of them, and you can't become involved in that. You have to refer that case out to another firm. You have a conflict, unless they're willing to waive it. But even there, the waiver is dangerous because you have you perceivably use confidential information to harm one of your clients. It's a risky action to take. The case I was involved in, State of Hudson versus Tibble, is a case where the lawyer, the conflict was subtle. The conflict occurred because the fiduciary in charge of an estate had conflicting loyalties, and this was a subtle one. This was a hard one to see, but when you have an estate, administrator of an estate, that person decides what claims the estate will pursue. Well, the decedent died without a will. His widow became the administrator of his estate. He also had a child from his first marriage who was 11 years old, so that's a minor child. So there was a disputed asset. The administrator of the estate, the widow, said, I really own the disputed asset, not the estate. The lawyer for the estate took the position that the estate did not own the asset. This created because the fiduciary, the widow, had divided loyalties. She was both the executor of the estate, the administrator of the estate, and making a claim against the estate. Because her duties were in conflict, her conflict sort of was imputed to the lawyer, and eventually he had to drop out, and an independent person was brought in to do the work on the estate. The point is that this is a subtle one. This is the case of where the fiduciaries pursuing a claim against their estate, the fiduciary's violation of her own fiduciary duty caused a conflict for the lawyer. So it's a subtle case, but remember, is the president of the company doing the right thing by the company? And these are questions, and because we had a minor child, the court system becomes very skeptical, and the court system says, no, we don't think you the lawyer could both represent the estate and claim it against the estate. So the lesson is the same one: clarify who you represent, and then if you detect a fiduciary who may be unfaithful, you probably have to take remedial measures to deal with that. Hey, we got a trustee here who's not doing his job, not taking care of the trust. He's also doing this. Well, that's that now you have a problem. You have to deal with that. You can't just blow that off and simply pretend that there isn't a problem. Another source of claims is suing to collect your bill. In Illinois, if you file a counterclaim against the hold on, that's gobbledygook. If you sue for fees, the defendant in the case can file any counterclaim for malpractice, even if that claim was time barred. So in Illinois, statute of limitations on a malpractice claim is usually 2 years. Statute of limitations on your claim for fees is going to be 10 years, written contract. You can't wait 2 years and a day and sue the client for fees. That will waive the statute of limitations on malpractice, and you will subject yourself to an expensive claim. So think long and hard before suing for fees. That's in Illinois. Other states have different rules. New York is a state where you can wait for the malpractice statute to expire and then file a claim for fees. Other states are like that. Illinois has that provision in the statute that essentially reanimates any claim the client would have had. Some self-defense thoughts on should you sue for fees. Have someone else look at the file. Is a claim could this boomerang on me? Could there be some type of claim made? How will an angry and vindictive client try to invent a claim against me? How would this person react? And then finally, is the amount due, how much fees you're owed, worth suing over? And the answer is often it rarely worth doing. Some lawyers will put an arbitration clause in their engagement letter that says any claim has to go to private arbitration. It's a good idea. It protects you from the client running to the courthouse and suing you. The downside of arbitration is that it's expensive. You have to pay the judge's hourly rate, and that's could cost a lot of money, and you could end up broke before you could end up spending more on costs and fees than you would in a typical piece of litigation. So arbitration can work great, but if you're trying to collect money, it's not a good plan because it's going to end up being too expensive usually to use it. Defenses. The main defenses are, the statute of limitations is run. That's the most common, most successful defense. The next one is we didn't represent the plaintiff. He wasn't our client. That's a good one too, provided you documented your file. And the third defense is, of course, we met the duty of care. Your matter just went poorly for you. We're sorry that happened. Fourth issue that comes up is the lawyer made a judgment call. Judgment call is something where there could be two alternatives that are equally plausible. The lawyer makes a tactical decision, strategic decision to choose one of the two options. And then the classic example is whether the criminal defendant should testify at the criminal trial. Well, maybe he will, maybe he won't. But the lawyer shouldn't be blamed for that because that is a classic judgment call. You discuss it with a client, you go over it, explain the risks, and you make your call. Important thing here is if it's important, document that you made a judgment call. Classic example for a defense lawyer is case comes in against your client, the surgeon. He's sued for an alleged error. Should you add in the radiologist? Should you add in the cancer specialist? Should you sue for contribution? And that's an important, that's a judgment call. Maybe you do, maybe you don't. Maybe it's worth doing, maybe it's not. this is this case from 2020. The lawyer said, I don't think these items will be subject to tariffs. The United States government disagreed. The lawyer said, well, it was a reasonable interpretation. I made a judgment call. And the court said, yes, you did. You didn't make an error. This is simply the ball bounced in a way that was not in your favor. Let's obviously think through how you're keeping your firm's data secure. And then the new issue in the law business that's causing a lot of adjustment is the issue of the use of artificial intelligence. If you disclose confidential client information to an AI agent, you are waiving whatever privilege attached to that information, so do not do that. And some people say, well, is there some type of private AI that won't train on your data or whatever? I don't know the ins and outs of that. I'm not sophisticated enough to know. But I would encourage you not to share anything with AI until there's black letter law and well-settled cases involving it. And don't waive the client's privilege. And obviously, you have to verify any AI research, because the AI, unfortunately, may make up an outcome that you wanted to hear but wasn't really true. That's a small problem. Waiving the privilege is much more serious, or not thinking through. AI doesn't think in a way a human being does. So make sure you've put human thought into everything. Make sure that you don't lose your client's data. This is an important one. Just make sure this is carefully thought through. Because that can get you a claim. When you withdraw in litigation, make sure to get permission from the court. Don't just drop off the map. It's inappropriate. You can really get burned. And then, do the things you need to do to withdraw carefully and protect the client's interest. Tell the client what deadlines are coming up. Confirm everything in writing. Think through whether you should try to protect the client. Like, is it a good idea to withdraw a week before the appeal has to be filed? Think about those kind of things. Be sensitive to the client saying, well, I didn't know about this, and now you dumped this on me at the last minute. Think that through a little bit. Obviously, you're liable if your colleagues, non-lawyer staff, or other lawyers make a mistake. Think through very carefully how you're going to supervise them. And then, get experience, and then make sure you do supervise them. I would encourage people to have independent calendars. Everyone should have a calendar in the office. There should be regular status meetings to discuss all the cases, and then clear procedures for telling the client, hey, you lost the case. The appeal is due in 30 days. If you want us to handle the appeal, the price is X. Here's our engagement letter. This is a little bit of a restatement of some things I said earlier, but be very careful to communicate all bad news to clients. We moved for summary judgment, it was denied. We made a demand, the other party denied the offer, or they offered $100,000. Who knows? Tell the client. Make sure you've done that in writing. Document client conversations with emails or with memos with the file. Just do your very best to make sure that you've thought that through. And then you for any settlement negotiation, get written authority for the client so that you can move forward. Explain the settlement authority. Give your professional assessment. Someone comes in and says they're offering X for the claim. Tell them what you think. Tell them your position. I think we can get more. I think we should wait till trial. obviously, another area of claims. These will be claims that will come from the state bar association. Are your trust accounting. Make sure you understand what's in the account, who it's owed to, whose money it is. Don't mix it with your own personal funds, so that you can protect the interests of your clients, and don't take fees before you earn them. Understand the rules. Maintain a separate ledger for each client, for the deposit that was made, the deductions from the deposit. Make sure you've kept careful records. Appellate, if you lose the case, make sure you've disclosed the date when they have to file a motion for a new trial or to file an appeal. Make sure you've thought about that and told the client. If you're going to handle the appeal, get another engagement letter. Say, this is what we're charging you for the appeal. This is what we think the cost will be. This is what we are asking you to provide to us, and by the way of a deposit. The more you communicate, the better. And if they don't sign the contract for the appeal, then don't do the appeal. Are you personally liable for someone else's mistake? You can be. You can be. The bigger the firm, the more thoughtfulness needs to go into what happens when a lawyer departs. How are we going to flag conflicts? How are we going to make sure we don't inadvertently sue a former client or get ourselves into conflict with one of our current clients? So the bigger you are, the harder it is, and the more people you need, and the more procedures you're going to need. I don't know if this is not really a defense, but any plaintiff in a legal malpractice case is going to need an expert witness to say the lawyer didn't meet the standard of care and that error caused harm to the client. The problem with this is many of the plaintiffs won't be able to come up with an expert. So if you're in the world of the defense, you may be tempted to wait until the plaintiff has an expert before you discuss settlement or take any serious action. If they don't have an expert, there's just nothing to it. Defense should have its own experts. Briefly on malpractice insurance, everyone involved in a litigation practice should have malpractice insurance coverage. Promptly report any risk of a claim to the insurance carrier right away. If there's some dispute arises or the bar complaints filed, tell the carrier about it so you don't risk it being excluded later because you didn't report it on time. Don't sit on these things, report them. You are better off reporting them. Don't worry that your premium would go up. That's a cost of doing business. If you don't report it, they don't have any duty to cover you. And then if you're leaving your firm or exiting the practice, consider tail coverage to protect you from a late arising claim. The ball bounces in a way that's unpredictable and that you've now subjected to a serious claim. So tail insurance is a must. So if you want to avoid legal malpractice claims, avoid bad clients, use a clear engagement letter that excludes tasks you do not agree to perform, such as an appeal. Meet deadlines, document your file, give blunt advice to people in writing. Then if you're going to sue people for fees, review the entire file before you sue someone. Don't sue for a small balance ever for any reason. Don't sue unless you've done a self-critical review of your work. Is there any way this could blow up on me? And if you're worried about an issue, consult a trusted colleague before you make the final decision to sue or withdraw from the matter. Sometimes that person can offer you some valuable advice, have a little bit of a critical perspective, and it will avoid a claim that would come in the third party, the other lawyer, the other person may be a little more impartial than you and may see the danger. So when you're out there, don't be afraid to ask someone to go over it with a senior lawyer. So I thank you for your time. Thank you for listening. I hope the presentation was helpful to you. Thank you very much. If you have any questions, leave them in the comments. Thank you so much for listening. Bye-bye.